nothing that Trump has pursued since taking office has followed the sort of settled and in many cases legally and constitutionally required routes for changing policy. And so I do think that any criticism that, well, people who are unhappy with the way things are going are just unhappy with the substantive positions that Trump is advancing, I think are just fundamentally wrong.
Kate Shaw, welcome back to the show.
Hi, Preet. Thanks for having me back.
So we have a lot to talk about. We only have like an hour. I need 9 hours. So can I ask you a preliminary question before we get into some current events?
Yeah.
And things that are winding their way through the courts? Because other people have said this to me. Is it really, really difficult or impossible or not difficult these days to teach constitutional law?
It's really difficult. Yeah, it is. I mean, it's especially difficult. So, to stand up in front of a classroom and teach Youngstown, right? The case that sort of famously stands for the proposition that the president has limited authority. The Constitution or a statute has to give the president a power if the president purports to exercise that power. And that remains the law of the land. And so there's the majority opinion and there's the very famous Jackson concurrence. And they approach the question in slightly different ways, but the bottom line is the president is not a king and is limited in his authorities. And just the disconnect that I think the students feel between the law on the books and the law in action is just this there's this chasm between the two in terms of what we are seeing playing out. And that doesn't mean that the law they are learning is wrong or irrelevant at all, but it just does mean there is deep tension. So I think that's more true about the kind of structural constitutional law materials, at least so far, a lot of the equal protection and liberty guarantees in the Constitution, as the cases have interpreted those guarantees, haven't been fundamentally challenged, although, it's early. But I think that's the source of the difficulty.
Does that say something about what's happening? That in ordinary times, constitutional law principles in the case law don't vary so much, so you don't have to reinvent your curriculum every semester or every year? Is it a bad thing? Is it a good thing? Does it depend on your perspective?
It's hard for me to, even if I want to, kind of step outside of my own perspective, it's hard for me to imagine defending as a good thing the speed and magnitude of the upheaval that we are seeing right now. So, I was a law professor in the first Trump administration, and I do think I'm able to step outside of my own views, effectively enough to say, of course, a Republican president, of course, a President Donald Trump is going to make policy that I don't like. But I don't think that's the fundamental problem. It's certainly not the constitutional problem that I'm identifying. But I think that if Trump was doing everything that he has done since taking office through the ordinary process of working with Congress, which again, by the way, he controls, right? His party controls Congress. You can, through lawmaking, change the structure of agencies, the staffing of agencies, the substantive policies to be carried out by agencies. If you think USAID is doing more harm than good in the world, you can eliminate it, right? You can reduce it or eliminate it outright. But nothing that Trump has pursued since taking office has followed the sort of settled and in many cases, legally and constitutionally required routes for changing policy. And so I do think that any criticism that, well, people who are unhappy with the way things are going are just unhappy with the substantive positions that Trump is advancing, I think are just fundamentally wrong. I think that everybody understands elections have consequences, and Trump is going to pursue and was always going to pursue a very different vision of the country and of government than a President Harris would have. That's not the problem. The problem is how.
So let's start with some easy stuff that's going on at this moment. Then we'll talk about some stuff that's happened in the past, and then maybe I'll ask you to predict the future. So goes to Supreme Courts, present, past, and future. So I'll start with an easy one. We have this thing called the Education Department. It did not exist at the founding of the Republic. It's a fairly recent creature of, this is important, of statute. There's a lot of employees. It's a lot of functions. Why can't the President of the United States, as the all-powerful executive in whom all executive power is vested, just dismantle the Education Department?
I don't think he can create or destroy much unilaterally. So I don't think if
it's
he wanted,
like matter,
right? It can
matter
be created and also
destroyed
by the president. But I think to go back to what I said a couple minutes ago, I think that if the president decided, again, education is a state and local matter and the federal government should have nothing to do with it, I think that Congress can eliminate the Department of Education. The Constitution doesn't require it. The Constitution doesn't require any particular structure in the executive branch.
So so play it out. He doesn't have the votes for that, but he thinks he ran on it. I don't know if he did or not. I can't remember. I don't think he did run on dismantling the education department, but he issues an executive order and tells his secretary, start winding things down. People sue. What are the arguments going all the way up to the Supreme Court that the president makes about his authority to completely eliminate the Department of Education? And what are the arguments on the other side, and who wins?
Yeah. And did he run on it? I think you're right that he didn't, but I do think it was in Project 2025, which he disavowed, but is really carrying out. So he did kind of run on it. He just sort of denied it.
Yeah. Well, whether he ran on it or not, does that affect the legal analysis?
No, I don't think so.
Okay.
So, there are a couple of different things. One, there is, a set of statutes that Congress has passed that create this thing called the Department of Education, that give it all kinds of different authorities to manage federal loans for higher education, to, provide various kinds of protections for students with disabilities and who administer a statute called the Individuals with Disabilities Education Act. A number of federal statutes are implemented and enforced through individuals employed by the Department of Education. Congress has passed those laws. The president has no authority to repeal those laws. And the president's constitutional obligation to take care that the laws are faithfully executed includes all the laws passed by Congress, including those. And that's just two examples, student loans and students with disabilities. But those are two important statutory mandates Congress has given to the executive branch, and they're carried out through the Department of Education. So you can't faithfully execute those laws without bodies, like people employed by the Department of Education to do that. So I just think it is facially inconsistent with that core constitutional obligation for the president to say, I'm going to dismantle the agency that is carrying out those laws. In theory, I think he could do a lot of restructuring so long as the basic commandments, the basic directives in the laws passed by Congress are still heeded, but that's not what's happening.
So those are the arguments that would be made against it.
And actually, that's just one. Sorry, I won't go on too long. But also, there's funding. They're just Congress has appropriated money for the Department of Education.
What argument? What's the Trump lackey going to say in court?
I can't believe you're going to make me do this, Preet. I have to make those arguments.
You're a lawyer by training.
No, of course. And I tell my students this all the time. I mean, all executive power is vested in one president. And in order for the president to faithfully execute the laws, the president.
Could you do this with a little more feeling?
That sounded pretty dutiful, didn't it?
You look like you're in a hostage video.
Look,
feel it a little bit.
I honestly think that unilaterally dismantling an agency is not so different from the president issuing an executive order that says, I now have a co-president, and it's Elon Musk. Like, the president has decided he wants a co-president. And so he issues an executive order so announcing. And that's absurd. There's no universe in which the president can unilaterally do that. And I honestly don't think it's that different to issue an executive order that purports to say this agency that is a creature of statute is no more. I don't think he has the authority to do that. So I will go down this path a little further with you if you want, Preet. But I think it generally speaking has to reduce to an argument that the president has a democratic mandate, again, which is why maybe it's a little legally relevant whether he did or didn't say he was going to do this, but only kind of peripherally. But he has a mandate, and he is carrying out the mandate in the way he sees fit. The mandate from the people, right, in whom all sovereignty and from whom all sovereignty, right, resides and flows. And so this is the best way to kind of carry out that democratic warrant in his view. And he is the single president, most democratically accountable, et cetera. And essentially that is the claim. It's an assertion of raw power, I think, with a little bit of kind of constitutional underpinning, but and I'm sure his lawyers will do, if in fact this particular case or some version of it ever ends up before the Supreme Court, they'll do a more detailed job than I just did. But I think that's basically what it reduces to.
Yeah, I mean, they've made arguments that are just as outlandish as that before. If I recall correctly, that in the big immunity case, one of Trump's lawyers made the argument that, yeah, he can assassinate someone if he thinks it's within his jurisdiction or his duties as commander-in-chief and president of the United States. They made that argument with a straight face, did they not?
Well, they didn't resist it when the hypothetical was posed in the D.C. Circuit. Yeah, they didn't lead with it. They went like, this is what we're asking for.
They're not that terrible.
No.
So are most of the arguments on these things going to end up being, as we saw with the Perkins Coie executive order that I want to ask you about also? Look, I don't have to get into the niceties of, what the consequences are of this action, what the statutory framework is. None of that matters, because once the president says national security or invokes some other privilege and responsibility unique to the executive and obviously unique to the president, in whom all executive power is vested, that's the end of the story. Is that the argument on most of these things?
A lot of them, yes. It's hard to make that argument with the Department of Education, right? So, but I think it's right that
you can't make you could do it. I bet you could do it, Professor.
I mean,
make a national security argument in favor of dismantling the Department of Education.
I mean, look, that at a high enough level of abstraction, right? Like the national security is served or advanced by an educated populace, right? Like able to compete with our adversaries, both economic and military. And the president believes it's in the best interest of training the citizenry in order to meet the global threats of the moment to dismantle the Department of Education. I think, again, that was pretty bad, but I think you could try to do some version of it.
I thought it would, look, okay, is there any, so you make that argument. Is that a 9-0 loss for the president or not?
7-2.
And you think it's pretty bad, but there's two, which two? Alito and
Thomas.
And Thomas?
Yeah. For basically anything. I think it's very hard for me to see. Now, look, I mean, they were actually, and that's the current version of Alito and Thomas. I mean, as recently as a couple of years ago, I guess 5 years ago, the Vance case, right, involving the previous Manhattan DA's request for the records from Mazars and some other, financial institutions for Trump's records, he went to the Supreme Court with an argument that sort of presaged a lot of what was in the argument that ultimately prevailed in the big recent immunity case, basically saying like, the documents, they're my finances and I'm the president. And so I have some categorical protection from ever having to disclose them to anyone. And even Thomas was dubious about it. He rejected the really maximalist version. Alito kind of did too. They wrote separately, and they were more sympathetic to Trump than the rest of the court, but they didn't sort of hook, line, and sinker by that argument. But fast forward to July 1st, the big recent immunity case. And I just, after that opinion, I think it's really hard for me to imagine at least those two ruling against an assertion of presidential power, no matter how outlandish.
Yeah, so this is maybe a dumb question, but why is it only 7-2? Did the president and his people make a mistake from their perspective in appointing people like Gorsuch and Amy Coney Barrett who are not with the program of unitary executive? Or is it such a bizarre judicial viewpoint to have that they're not credible people to elevate from a circuit court to the high court who believe that?
I think there are a couple, maybe more than a couple, who you could, if you got another shot, if you, as Trump 2.0, had a chance to elevate someone. I think Judge Ho in the Fifth Circuit, for example, would be, an absolute vote with Alito and Thomas on most, if not all things. But your kind of deeper question, it is interesting and conspicuous that Trump's two most reliable votes for the most maximalist claims of executive power are not from the people he personally appointed to the Supreme Court. They're from Thomas and Alito, who are George W. Bush appointees. Yeah, I mean, I think a couple things. One, I mean, they're somewhat younger, and I think they are still at least somewhat immersed in kind of what I would call sort of reality-based silos of information and media and kind of, culture. And I think they still read probably the New York Times occasionally, those three being Gorsuch and Kavanaugh and Barrett. And I don't think that's true about Thomas and Alito. I think they seem, I don't know anything about this. I have no inside information, but my strong sense from their demeanor and questions at oral arguments and the kind of, talks that they occasionally give on campuses and such, is that they just kind of reside in a far-right news bubble that has kind of unmoored them from kind of facts and reality. And I just don't think that's totally true about the other three.
But they get the briefs from the other side, right? They read those?
They read them through. We all make meaning of the world, right? Through the lenses that we bring. And I think they have so skewed their lenses that they aren't even really able to read in good faith opposing arguments.
Would it be trite and or anti-intellectual to say that they've just become grumpy old men?
That's basically what I'm saying, right? They've been a little bit pickled. Their brains have been a little pickled.
Will Amy Coney Barrett eventually become a grumpy old man?
this is, the big question of the moment, because at least recently she has, broken somewhat with the conservative bloc on the court. And it's, caused a lot of consternation on the right.
Yeah.
People are very unhappy with her.
Can you explain that? Can you explain that to folks?
Sure. Yeah. She just, she's broken in a couple of recent cases. She's broken a few times with the conservative majority. So most recently in this case in which the Trump administration tried to get the Supreme Court to block an order by a new district court judge, Judge Amir Ali in the District of D.C., involving, essentially $2 billion in unmade payments that USAID was already obligated to pay, often for services and goods already provided, but that this kind of DOGE group had directed the USAID to stop paying. And, following a lawsuit, Amir Ali ordered these payments to be made, and the Trump administration ran to the Supreme Court and sought to put that order on hold. And the administration lost 5-4. And unsurprisingly, right, the Democratic appointees voted against the administration, and so did the Chief Justice. And that's not that surprising because he's done that on a number of occasions. But maybe more surprising was that Barrett supplied the fifth vote, which meant that Ali's order stayed in force. And at least in theory, all of those payments should be already made or ongoing this week. And so that was viewed, I think, as a profound betrayal, and that the other conservative justices they would have voted with the administration. Alito wrote an 8-page dissent, right, to append to the 1-paragraph order ruling against the administration. And it was that. And there was also an EPA case last week in which the conservatives on the court, all the men, voted with the city of San Francisco. Actually, it was kind of an odd lineup in this case, but San Francisco had sued the EPA over some water discharge regulation. And San Francisco won, EPA lost, and Barrett wrote the dissent, joined by the 3 Democrats or Democratic appointees. And it was pretty unhappy with the majority opinion, and it was Alito's majority opinion. So those are a couple of recent examples. There have been others, but they have led some conservative commentators to essentially suggest that she's either a turncoat or was always unqualified, or maybe both. And it's been pretty outrageous, some of the rhetoric based on just this one shadow docket order and one EPA case that probably no one really has ever heard of outside of kind of illegal circles and environmental circles. And but it's been striking.
They have taken to calling her the DEI justice. What percentage of that is misogyny?
I mean, most of it, a lot of it. Yeah.
They haven't called John Roberts that, have they?
No, but of course he's a man. He has no race nor gender, right? He is just a justice.
He just calls balls and strikes.
That's correct.
He's a balls and strikes guy. Umpires don't have race or gender. Didn't you know that?
No, they don't. They just have those uniforms. That's it.
I guess my question about Amy Coney Barrett is, my other question is, was any of this foreseeable? In other words, to be disappointed, you had to have had an expectation. Was there expectation about her rulings in particular areas in error, or did she change, or what happened?
Well, it's a little early, I think, to make any big judgments. I think that she was picked because she is, kind of rock solid conservative on social issues, and she has absolutely been that. She, cast the 5th vote. Roberts was a 6th, but wrote separately. She cast the decisive vote to overturn Roe versus Wade and Planned Parenthood versus Casey. She was fully on board with the dismantling of affirmative action in higher education. She, has been a reliable vote in even the big executive power cases that we've seen on the merits docket. But she has not been totally lockstep on every single issue. I mean, again, neither actually has Gorsuch, neither has really Kavanaugh. And so it's, I think, conspicuous. And to your point about how much of it's misogyny, I think the proof is pretty clearly there. Kavanaugh was the one who defected on a big Voting Rights Act case last year, 2 years ago, rather, and not Barrett. And I don't think anyone called him a DEI hire for that reason. So I do think that the difference is pretty striking. But so I think we didn't totally know fully, apart from, she seems very socially conservative, and her rulings for her brief time in the Seventh Circuit seemed to bear that out. We didn't know that much about her. And And so I think she was a bit of a blank slate. And I think she is so far proving to be a relatively independent-minded jurist. She is distinct from the other conservative justices in her background in that she doesn't have executive branch experience the way all of the others and, some of the liberals as well do. She was just a law professor and then a judge. And so I don't think she has the deep commitments about executive power that these ex-executive branch lawyers, who are the majority of justices at this moment, really kind of bring to the job. I think that might matter. And there is a phenomenon over, the last, I don't know, however many decades of kind of leftward drift among Supreme Court appointees, right? It's not a kind of, universal, it's not an iron law, but it has happened.
Well, it didn't apply to Alito and Thomas.
So there are certainly counterexamples on the current court.
Yeah.
And I think obviously it'd be crazy to say, well, they haven't drifted yet, but maybe they will. And I mean, I am old enough to remember when I was a clerk on the court, like the year after Alito was appointed. And I think at that point there was some question, like he seemed like an open-minded and relatively moderate person. And obviously that was
he got a
totally
bunch
wrong.
of Democratic votes. Robert's got many Democratic votes, and he's turned out to be more moderate.
Yeah, but just to say one more thing. So the leftward drift is a phenomenon, but I think there's at least some academic work that suggests it's a real phenomenon. Lots of Republican appointees disappointed the presidents who put them on the court. And the kind of famous Eisenhower quote about like the sort of biggest damn fool mistake I ever made was putting Earl Warren on the Supreme Court. And lots of other presidents, I think, have said similar things about the justices they appoint. But it seems as though, to the kind of Alito and Thomas point, justices with a lot of law enforcement or executive branch experience who are appointed by Republican presidents seem to drift less than those who don't have that experience. So that could potentially explain the divergence between Barrett and the others. And it might mean that Kavanaugh and Gorsuch, who both do have extensive executive branch experience, are less likely to drift.
Sotomayor has law enforcement.
Yeah, local. Yeah. I mean, and Kagan, of course, like executive branch. And Jackson was on the Sentencing Commission, which is sort of an unusual body, but it's an agency of sorts. So I kind of think it's like kind of everyone. It's kind of everybody but Barrett.
That means we can't really tell, maybe. So I asked you about the Education Department. We're talking about the DOGE. Is it DOGE or the DOGE?
Just DOGE.
I think it's just DOGE. I'm going to ask you to do the same exercise. What are the strongest arguments in favor of sitting president having a guy like Elon Musk? We can talk about what his role is and how you characterize it. But having him and some other folks give advice about cuts to eliminate waste, fraud, and abuse within government. And what are the most powerful arguments against, and how's that going to work out?
I don't think there are a lot of arguments against the president convening a body to give him advice. I think that's fine. It's both, I think, constitutionally unproblematic, but actually back to our kind of original exchange about presidential power being traceable to something in the Constitution or a statute. There's actually a statute. Congress has really clearly given the president, by statute, the authority to establish what are known as temporary organizations in the executive branch, actually in the executive office of the president, right? The thing that the White House resides in. So there's a statute. There's no problem with him creating a thing called DOGE, and indeed the executive order creating DOGE essentially makes it the successor entity to this previous entity that was called the United States Digital Service. And it's supposed to be, like an 18-month kind of affair. But the job of the Digital Service, and in theory, I think at least the job of DOGE, is exactly as you described it, Preet, like studying, making recommendations, trying to like identify places to bring more efficiency and to reduce waste in the executive branch. And everything I just said is totally constitutionally, legally airtight. No problem.
So what's the problem?
That's not what they're doing. They are exercising so much more authority than they are, I think, permitted to exercise under this statutory provision the president relied on to create them.
I mean, I don't know if this is the case, and I don't know exactly if they're arguing this. But suppose it happens to be the case that you have an entity of the type that you described as an initial matter that you said was lawful, constitutional, and proper. But it just turns out that for whatever reason, given undue deference that the president and others may pay to that perfectly appropriate body, that their speeches become acts, and everything they say should be done is always done. Is that enough to put it into the bad category of thing or not?
I think the line might be hard to identify under some circumstances. I think it's not right now. But I think you're right. Like the president has people around him who provide advice, and where that kind of advice shades into exercising something like directive authority or, speaking to agencies in what you're framing as conversations, but where you're so obviously understood to be carrying the message of the president that everything you say is heeded. It's hard. It's hard, I think, to figure out where the line into illegality is crossed.
Is it because you have to apply common sense in the real world to this question?
It might be.
I mean, you and I, podcasters and professors both.
Yes.
Engage in hypotheticals. So, what if Donald Trump had a friend?
Not illegal, not unconstitutional to have friends. Totally fine.
But also not something that actually happens in the real world, right? I was going to say, had a friend like Vernon Jordan, very close friend of President Clinton. Let's say President Clinton.
Yeah, Clinton had friends, lots of friends.
Yeah, but suppose you got a friend,
yep,
and you don't set up a whole thing, and you play golf with the friend every Saturday and Sunday. And that friend keeps telling you, like, do this, do that, fire this person, fire that person. Here's what you got to do on tariffs. Is that fine?
Yes.
Does that ever morph into what you have here? And is that because that friend will not have been granted access to troves of documents at the various agencies, or is there some other delineating factor?
This is also uncharted. There is no test that a court has set forth or that we law professors have really ex ante kind of devised. But I think that if the friend, was demanding and receiving on protection of the U.S. Marshals access to federal agencies and the information contained therein, and giving directives to the heads of components and actually, cabinet departments about whom to fire, and sending messages to the federal workforce requiring performance of some specific act, like an email with bullet points describing the work you've done in the past week, I think that we would have a real constitutional problem. Now, how exactly to frame the constitutional problem? I think part of the problem here is that, we think about constitutional litigation as there's a particular provision of the Constitution that is being violated, and I'm going to bring a claim, and I have to figure out what test applies and how, kind of that test applies to the facts here, and sort of what rule a court should announce, and reason, how it should defend that rule and all that. And there is just honestly so much independent unconstitutionality, in my mind at least, that sort of surrounds DOGE, that it defies this capsule summation of here is the core constitutional problem. I do think that the appointments clause is one big one. I think that Elon Musk is exercising the power of an officer, and probably a principal officer the Constitution requires to be appointed by the president and confirmed by the Senate, and he has not been. But that is by no means the only constitutional problem that I see that sort of surrounds DOGE.
From that constitutional question, the appointments issue, which is essentially, as you said, he's exercising too much power to not have been appointed and confirmed by the Senate. How is that going to fare in the Supreme Court? And first of all, do you believe it will get to the Supreme Court? And if so, how will it fare?
I think good chance it gets to the Supreme Court. So there are, 3 cases pending right now, brought by current and former federal employees and states and groups, basically making versions of this argument. It's a very strong argument. Again, there is not the Supreme Court has said about officers who exercise far less power than Musk is clearly exercising right now, that they are officers, and maybe that they're principal officers, but certainly they're officers. So we're talking about administrative law judges at the Securities and Exchange Commission, and these administrative patent judges at the Patent and Trademark Office. And even, I think, the deeply misguided opinion by Judge Cannon in Florida, finding that special counsel Jack Smith's appointment was unconstitutional in the classified documents Mar-a-Lago case, because he was an officer of the United States and had not been appointed consistent with the Appointments Clause. Now, she was wrong. There was a statute that I think clearly authorized his appointment. But I do think that this idea that actually, in some ways, they have this kind of maximalist vision of presidential power and presidential control over the executive branch, including the personnel within it that you alluded to earlier in our conversation. It seems like that's actually, if you care about enforcing the way the Constitution empowers the president and the specific mechanisms in the Constitution that are set forth for, empowering individuals to assist the president, because even though he has all the executive power, he can't actually wield it all personally, right? He has to have assistance. And the Constitution, which is a document of lots of generalities, is really specific in this particular way about how officers are appointed. And so I actually think if you take executive power in Article 2 seriously, you kind of have to take the Appointments Clause seriously, and these cases clearly do. And so I think that if the court does approach the question in good faith, it should find some real problem. Now, let me say 2 more things. One, I can see the administration shifting in real time as it kind of comes into view the possibility that courts are going to issue merits decisions on this appointments clause question. And so you saw, last week, this hastily convened meeting of the cabinet in which Trump apparently tells his cabinet secretaries that actually they decide, Musk does not, who gets, fired from their agencies. And that feels like kind of they're in damage control mode. And I think there may be more like this where they seek to at least downplay publicly, if not formally, kind of roll back a little bit the power that Musk is exercising. And that, I think, would complicate the calculus under the appointments clause.
Well, they made one argument in court, and I want you to give it a grade in a moment. And compared to another argument we talked about earlier in the conversation, a lawyer got up in court and said, there is no evidence that the other side has brought to bear that Elon Musk, not only that he's not the head of the thing, but that he has any formal role at all. And then, of course, like 2 days later, the joint address to Congress, some guy, the President of the United States of America,
that guy, yeah,
said to Elon Musk, who's president, great job. I'm paraphrasing. Great job. And he's the head of it. We talked earlier about the lawyers who did not resist the hypothetical of a president having the authority to assassinate his political rival. Where do you put that on a scale of 1 to 10, 10 being the most ludicrous, outlandish, backfiring argument you could make, and 1 being a perfectly good argument? Where do you put the assassination argument?
Wait, no, not assassination. Where do you put the DOGE?
Well, I want to have a comparison. So
okay.
We have to develop a system here. So
no, one. Assassination's 1.
We don't meaning, I'm sorry. 1 is the worst.
Yes.
Okay. 10 is a good argument. 10 is a good argument.
Okay, whatever you framed it, whatever the worst is. I think you said 1, but you took your mind.
Play it however you want to play it.
Okay, so assassination's 1.
I still can never remember if DEFCON 1 is when I get under my table or DEFCON 5 is when I get under my table.
Yeah. Hopefully we don't have to find out.
So 1 is terrible. How about this? Elon Musk is not part of the DOGE argument compared to the other one.
Well, I think the actual exchange with the judge you're referencing happens before the joint address to Congress. So it's a little hard to grade it in the rear view mirror.
But even then.
I mean, I think that there are like really deep kind of like realism versus formalism questions. Your NYU colleague Rick Pildes has this great article called like Institutional Realism versus Formalism and the Separation of Powers. And it's like courts are sometimes reluctant to like look under the hood and question the representations the executive branch makes about like what's going on inside. And most of the time, I think it's probably right for courts not to pry. But I think that kind of presumption is rebuttable, and it's obviously been rebutted, I think, even before the president made that pretty significant admission from the perspective of this litigation that actually Musk is the head of DOGE. And I also want to say one other thing, which is this, I think it's really hard to give grades right now to people, to career lawyers in the Department of Justice who are in an impossible position. Like, I think the grade is a bad grade, but I also think that there are extenuating circumstances that if a student were in my class and I actually had to consider that they were, walking a tightrope of trying to defend the decisions made by the political leadership in the Department of Justice and the White House, consistent with their obligations to, of candor and as, officers of the court. And also this executive order, or was it a guidance memo, whatever the document was, that basically announced that nobody could ever diverge from the legal positions of the president ever on pain of termination. I mean, I think they just have an impossible set of competing directives to try to reconcile. And my sense is they're doing the best they can. So that's a dodge, but I'm going to stand by it. Not a DOGE, though.
It's not a DOGE.
No.
DOGE ball. Oh, I haven't thought of that.
I don't want to play. I really don't.
Yeah, I'm not sure all of them are doing the best they can, and you can always leave, and you can always make a decision not to make a terrible argument. There's this thing called credibility for people who actually practice in court. You have not been a judge. You would be a great judge or justice, Professor Shaw, but you've clerked for judges, and you've watched many arguments, and you know how these things work. Do judges and justices account for the credibility of an advocate, such that if an advocate comes in, because I have a view about this, and we may have a different view, and says preposterous shit on behalf of a client and debases himself or herself, either later in an argument for the same client, maybe even the same argument, it's a closer question about the credibility and the persuasiveness of the argument, the plausibility of the argument. Does there not come a time when a judge or a justice gives the argument less benefit of the doubt because of the asinine argument made earlier. Yes?
Absolutely.
Is that
I assume we agree about that. Yes, you think yes also. Yeah.
When I remember a very seminal moment for me when I was a very young prosecutor. And, my job was to do the right thing. And I tried to do that on every occasion. And people can have disagreements about whether or not there should be pretrial detention. I had one of my colleagues, Rachel Barco, on, who's just written a book about these kinds of things.
It's a terrific book. Your listeners should check it out. I did an event with her yesterday about it. It's a great
book. And she's a great professor and person. But I argued in favor of detention pretrial. There were lots of details about him, including that he was a risk of flight, including that he was a danger to the community. He'd been firing a gun in the open air in the Bronx. He had multiple bench warrants for his arrest. I'm not sure if he had legal status or not. And the magistrate judge said to the public defender, what's your position? And she argued strenuously for release. And the judge said, I thought this was a little bit unfair, but I will never forget it. It's 25 years ago. The judge says, obviously you're making this argument because your client insists and you have an obligation to your client, but you should also think about your credibility before this court because you're going to be here a lot. I know you weren't there. You didn't hear the details. Is that a fair admonition or not?
I mean,
it's a little tough.
I actually think I'm not sure that's fair. I think it might be more fair to a government lawyer making arguments in a civil case. I think if it's a criminal defendant whose liberty is at stake and who is asking you to seek their release, in particular in some of the Rachel's first chapter about Salerno is all about this pretrial detention question, which is a hard constitutional question. And I have not ever practiced criminal law, so I certainly am not going to tangle with you on it. But I think it might be different. No,
I don't disagree with you.
Yeah.
I don't disagree with you. But and the reason it's stuck in my mind is just, I think maybe it was misapplied in that instance.
Yeah, but that the instinct is unavoidable, maybe.
It's important. And I just wonder, do you have, this is maybe a totally unfair question. There are times when it's very clear that in public statements that are put out by other officials or by the press office, that portions of them have been dictated by the President of the United States. And I'm sure computers could figure this out. And you know that by syntax, spelling, construction, attitude, and everything else. And that was certainly true in various of his personal court proceedings, that there was a Trump flavor, and maybe lawyers began to channel him, and so it wasn't directly coming from him. But on some of this stuff, do you think Trump is directing some of the arguments here? Or is it just people like Stephen Miller and others, some of whom are not lawyers, who are preaching about the unitary executive theory? Any sense?
I totally agree that some of the written statements do feel like they're coming from him, but yes, maybe the staff members have learned his voice and are channeling it really effectively. So who knows what it is? I think at a very high level, kind of all power in the president and eliminate pockets of kind of friction or pushback or opposition. And I think that's the sort of spate of firings of these independent officials that we saw in the first couple of weeks of the administration, and defending all that under this kind of maximalist vision of the presidential power, the kind of flip side of the appointments coin we were just talking about. So I think at a very high level, like that is the directive, like just assert all the power. But I highly doubt the kind of specifics of the legal arguments are ones that he has even kind of like any knowledge of. But I do think that in terms of if this is sort of buried in that question also, I actually think that in terms of how much it matters that he said that Musk is the head of DOGE, and that's one instance, but I think it's a phenomenon that we're likely to see play out in a lot of this litigation, where there's this kind of disconnect between the representations made in court and the things that Trump is personally saying or dictating in press releases. And I've written about this a decent amount, and I actually think that it's a mistake for courts to basically immediately sort of treat as like a party admission any statement the president makes that bears in some way on the kind of lawfulness or constitutionality or meaning of some executive branch action that's being challenged, like we saw in the DAPA litigation when Obama did the DAPA, the follow-on to the DACA program, which was the Parents of Americans. And Obama had said something very casually during like a speech, and the district court judge in Texas, considering a challenge to DAPA, basically said, you admitted something, and used that as a sort of core reason to invalidate DAPA. I think that's actually inappropriate. When you're delivering a scripted speech in this very formal setting of Congress, and you say something considered like Elon Musk as the head of DOGE. I think it's completely legitimate and in some ways necessary for a court to consider that, if that's the question, like, is Musk the head of DOGE? But I think that it's not always the case, that it makes sense, even if it's tempting, to sort of accord legal weight to every utterance that kind of comes from the president or the kind of apparatus around him.
Yeah, I mean, if it's one data point, that's one thing. And if it's a throwaway line, that's one thing. But if you have the legal equivalent of the question being, is something a duck? And it really quacks like a duck. It really walks like a duck. It really does all those things that a duck does. And yet the opponent in the court litigation, that's no duck. It's not a duck. And then the owner of all the ducks, right? The leader of all the ducks says, that's my duck. That's a duck. That's slightly different.
And I think that's essentially what you had.
Yours was a much more eloquent analogy than...
I'm just not sure of the duck leader.
I was trying to think, like,
what does one call
what if
a
the commander-in-chief of the ducks? But it's not really, because the ducks are not... Anyway, which of the executive orders issued so far by the Trump administration is the most worrisome, nefarious, and insidious, and why is it the one directed at Perkins Coie?
Oh, isn't that great? Yeah. So yes, I mean, I think
I didn't mean to put that in your. I mean,
no,
do you think it's one of the worst?
I mean, I think that some of the kind of targeting trans individuals orders are from the perspective of a commitment to kind of baseline sort of liberty and equality, and the use of government power to violently target a disfavored minority is odious constitutionally. And so I'd put a few of the executive orders in that category, just unbelievably constitutionally offensive. But I also think you're right, that in terms of, you're like, what is the most unconstitutional of the many unconstitutional orders that have issued from this White House? I do think the one targeting out of pure, petty, retaliatory animus the law firm of Perkins Coie, because of its representation of Hillary Clinton and various other sort of liberal associated or Democratic Party associated activities, to essentially try to destroy them as a law firm, which is what this executive order does, might be the most flagrant. It might be the most straightforward in its unconstitutionality. There are other, there are sort of similar, I thought, this is not an executive order, but the acting U.S. attorney in D.C., Ed Martin, who sent a letter to the Georgetown dean last week, right, basically saying, we're not going to hire your people or interview them even if you continue to kind of maintain the curriculum that you are maintaining, was also like on the kind of scale of, I think David French referred to this in the Times as like the most unconstitutional letter he had ever read, or one of the most unconstitutional letters. So anyway, so there's a lot of kind of candidates, but I think the Perkins executive order has to be near the top.
What do you think is the most significant weakness of the Perkins Coie executive order? So Perkins Coie hired another very prominent law firm, Williams and Connolly, very significant and powerful complaint alleging violations of the First Amendment, the Fifth Amendment, and the Sixth Amendment. Have you looked at it closely enough to have an opinion as to how it will go and on what ground?
So there was a hearing before Judge Howell in the D.C. in the district court last week, and the dispatches from inside the courtroom suggested that this was just like a kind of let me count the ways this is flagrantly unconstitutional. That seemed to be the tenor of the hearing. And then the order that the judge issued from the bench, I don't think we've seen a written opinion yet. But yeah, I mean, I think that, punishing a law firm, singling out by name and punishing a particular law firm for substantive positions taken by the lawyers at that law firm, whether it's a law firm or not,
who are no longer there,
who are not even there anymore. And this is all like a lot of this conduct is a decade old. I mean, this is a man who really bears a grudge. There is no question about that. Is an enormous problem, right, under the First Amendment. It is also, in general, a government can take stuff from you, can take tangible things and intangible things. It does it all the time. But we have this basic concept of due process, right? Like, you cannot be deprived of things like property, right? Which you absolutely have a property interest in the good name of your law firm and your law firm's ability to access federal buildings, which the order purported to eliminate for Perkins in the security clearances that you have been granted in order to, engage in certain representations that require access to classified information. So you have absolutely probably both a property and a liberty interest in those things. It maybe sounds abstract, but there is absolutely case law that makes really clear that those are the kinds of things that the Constitution's protection of liberty and property kind of encompasses. And you have a right to due process before the government takes those things from you. So if the government wanted it to set up a procedure by which it re-examined the security clearances of all of the lawyers in the private bar to whom such clearances have been granted, and it wanted to kind of take a fresh look at the kind of need or appropriateness of granting those security clearances, and you had a chance to defend yourself and explain why you still needed the clearance or still deserved it, there's absolutely a way the government could have done that. It couldn't have singled out just Perkins for it, but it could have done a sort of broader review potentially. It could even have said that with respect to access to federal buildings and law firms. But again, it's not, I don't think it could have, there's no constitutional path, I don't think, to this particular outcome. But there was not even an effort, as far as I could tell, to appear to kind of respect core constitutional values. In some ways, it felt like it was written to be as obviously and explicitly unconstitutional as possible. And, well done, drafters, if that was your goal.
Yeah. So here's what I think about that. I think you're completely correct. And it is because these guys engage in deliberation and decision-making before they take an action, whether it's filing a lawsuit, which has been, a habit and custom of Donald Trump for a long time, not just threatening them, but bringing them. That likelihood of success does not enter into the calculation, which it does for most lawyers, even government lawyers, in part because the vendetta is the vendetta, and you got to take whatever action you can. But it's also about the message that you've sent, not just to Perkins Coie, but reasonably to every other law firm, which is all the law firms, who say, there but for the grace of God go I. And the lesson that you're teaching, I don't know if this part of it's deliberate, but it's a nice, bit of gravy if you're the President of the United States with a certain personality and vulnerability, that, if we have the temerity to take on any interest or cause that is in any way near and dear to the sitting presidents, we may get an executive order. That's why I think it's the most insidious. It's not just what it does to this particular player, but to all the players. And that's true again, in instance after instance, right? Whether it's proper or not to fire wholesale federal employees, even if they have the protection of the civil service, you're telling legions of people, yeah, you know what? I best not apply to the federal government because that job is not safe at all. When you adopt birthright citizenship cancellation as your policy, it's telling everyone in the world, whatever happens ultimately in the Supreme Court, don't come here because your citizenship is not secure. When you send questionnaires, sorry, I have a little rant. When you have questionnaires that you're giving to FBI agents to find out if they have touched even remotely the January 6th prosecution, every FBI agent for all time, at least for a period of time going forward, has to think, am I going to actually serve that subpoena? Let me figure out first if that target or that subject is in any way related to the president, because otherwise they're going to yank my livelihood. They don't seem to give a shit about winning because they accomplish so much just by bringing the action. Is that fair?
Yeah, I'm now regretting not listing the birthright citizenship executive order as also at the top. I don't want to leave that out. And also near the top. I think that when you said they don't think about success, and in some ways, so that's I think right, that there's kind of expressive function is a big part of it, but that's part of why it's so puzzling that they seem so indignant when action after action is enjoined by the district courts, right? Like that's something puzzling, and maybe that's just posturing too. But they seem genuinely they are on an incredible losing streak in terms of the legal challenges to many of their initiatives. They got a rare win with respect to the head of the Office of Special Counsel, right, who won in the district court but then lost in the D.C. Circuit. But otherwise, I'm hard pressed to think of a merits win that this administration has gotten on any of these orders. They've won on a couple of there's no standing, like those kinds of kind of wins. But on the thing you did that is being challenged as unlawful, like actually seems lawful. I don't think a judge has said that about anything they have done. And it's because it is just a campaign of lawlessness. I mean, it's pretty clear. But they are the kind of manufactured outrage, indignation. We're drawing up articles of impeachment against district court judges who are finding these moves unconstitutional. But maybe that's all part of the same communication strategy.
Yeah, but I'm wondering. Tell me if I'm making too much of it. That it's almost as much an intimidation strategy and an intended chilling effect to be caused against sitting judges than just an overall communication strategy with respect to the action they're taking for the public.
Yeah, it's both.
I mean, the thing that I found very disturbing, and it's a small thing, and it's a little bit inside baseball, but on this one issue of many, where the question was, can people from the DOGE who are not vetted and not given security clearances, can they get access to sensitive Treasury information? And and people in the podcast have heard me say this, I think, before. There was the duty judge, I think on a Friday evening, Paul Engelmeyer, he's a great lawyer and a great judge, for like 3 minutes said, we have to take a pause. He's not even the permanent judge in the case. It was a mild and like really utterly reasonable thing. People can differ. Maybe he didn't have to grant it, and maybe a different judge might not have. But it was so mild. And you have a United States senator calling that a judicial coup. And all sorts of calls for impeachment on things that are they're not earthquakes. And there is recourse in a system that is overly stacked with the judges who are appointed by your guy. Why are they freaking out so much?
Yeah, I mean, the Engelmeyer order is also, I think, what precipitated the Vance tweet about kind of, sometimes it's okay to disobey judges, which is, we can sort of parse that.
So are they laying the foundation for that? Is that what's going on?
Maybe. And I think they have some, kind of assistance from some law professors who I think are sort of outrageously seeming to kind of defend the most charitable kind of reading of that. I think it's obviously a possibility. I mean, I think they have certainly been perfectly happy to defy one co-equal branch, Congress, in terms of many, many, many laws that Congress has written that they are flagrantly violating. And now they have a theory, which is that these statutes that they are facially violating are unconstitutional because inconsistent with this unitary executive vision of the presidency. But, that's what I think is so dangerous about some of these, senators seeming to kind of lay the groundwork. If they have a theory they can offer that the judges are acting in a way that's illegitimate because they are overstepping their authority. So it wouldn't be actually kind of, breaking the constitutional order to defy a judge, but somehow like restoring it because it's the judge who has done that. And I mean, it's a facially preposterous claim. Like the Engelmeyer order is a perfect example. It was a couple of days, totally modest. And by the way, also like even after sort of more consideration, I think clearly DOGE was getting some unlawful access to Treasury and other OMB and lots of, CFPB and other information. I think that it seems pretty clear that that's a possibility for which we have to be prepared. I'm certainly not willing to concede it's definitely going to happen, but I think that thinking through responses is important. And I don't know. I don't see if they think they're going to intimidate federal judges into kind of like not ruling against them, at least so far, I don't think that's likely to work. But I'm sure that's the goal.
I think you referenced this, but I'm not positive. To what extent is there some kind of argument that the broad immunity decision from last year about President Trump is enabling him and his team to engage in these activities with greater impunity than they otherwise would have? Is there a connection?
Maybe. I mean, I think it is kind of the backdrop of the whole first, nearly 2 months of the administration. I just think that how actively concerned. Well, I mean, I don't know. I'd be curious what you think about this. How actively concerned Trump was, and how actively constrained he was in the first term by the possibility that he might violate a federal criminal law and find himself charged down the road.
Maybe not much.
I don't think it was that active or powerful a deterrent. I do think the people around him were worried about it. I mean, for sure, Don McGahn's advising him in his conduct vis-a-vis Comey and others was concerned about violation of the federal obstruction of justice statute. And so there's lots of moments where I think the fear of the people around the president that someone might face criminal exposure was hugely important. And that's just gone. Now, on its face, the immunity protection in the Trump versus United States opinion only applies to the president and not the people around the president. But I think if you pair that kind of newfound freedom from any possibility, realistically, of ever facing criminal charges for essentially anything you do as president, you pair that with the kind of eager kind of relishing of the wielding of the pardon power that we've also seen in the first 2 months. So Trump can't be charged. And if anyone around him ever is, he could, again, not ever is, he'd have to be the president to exercise the pardon power, but he could pardon preemptively before leaving office or pardon if it looks like anybody is seriously likely to face criminal charges, anyone who assists him in doing anything. And so I think those two together rightly have resulted in this kind of air of absolute sort of impunity from any kind of consequences on the part of Trump and the people around him.
What are the cases that you're looking at and caring about that will be decided before the summer or by the summer, and that people should care about?
Well, a lot of the big ones, I think we don't know yet, because I think there will be now how quickly all of this will actually end up before and get decided by the Supreme Court, I think is a big open question. So there's already an emergency motion pending arising out of the Birthright Citizenship cases that have been making their way up through the courts of appeals. So far, the Trump administration is over 3 in defending its order purporting to end birthright citizenship. And that is likely how I would predict the court to rule. Although I think there's a bunch of different ways they could get there. And to our earlier point, I think that Thomas and Alito are probably in the bag for Trump, but I don't know about the others. And I'm not totally sure, honestly, even about them here. Like it's that egregious. So that one, there's, again, emergency motion pending. Administration has to respond like in 2 weeks. And then we'll see. That could be set for argument next fall, or they could fast track it and decide it this spring. I do expect they'll take it at some point. And that'll immediately become, one of the very big cases this term. I think that they will get one of the cases involving Trump's firing of an individual who has statutory protections against removal. And then that will really call the question of the future of this 1935 case, Humphrey's Executor, which allows for agencies to have a degree of independence, including being, led by individuals who can't just be fired at will by the president. And so I think very likely that precedent will be overturned. And the question, to my mind, is just like which of the many vehicles the court will take that presents it. So those are like hypothetical down the road. There are also cases pending. There's Scrimeti involving a prohibition on gender-affirming care in Tennessee that the court has already heard arguments on and will be decided this term. I think the court is likely to uphold that prohibition. And I think the question is sort of what else it does and says that might bear on sex equality.
What do you think? So just to be clear for the listeners, you think the court will uphold
the ban? Yeah. So Tennessee
the ban
banned gender-affirming care, right? So Tennessee said physicians can't provide, families can't get gender-affirming care. So if you're a kid assigned like male at birth, you're prohibited by law from getting, estrogen or hormones inconsistent with sex assigned at birth. Now, you can get hormones that are consistent with. So like if you need estrogen and you're assigned a girl at birth, you can get estrogen. So it's a very sex-based classification. And that's essentially the thrust of the challenge, that, laws that draw lines on the basis of sex get heightened constitutional scrutiny. Courts have to take a closer look at them and decide if they're supported by a sufficiently good reason. And actually, the Sixth Circuit, the Court of Appeals here, said this actually isn't even a sex classification, so it doesn't draw heightened scrutiny, and it upheld it on rational basis review. So what kind of scrutiny it gets and whether the court ultimately upholds it are sort of the two big questions in this case.
What's your prediction about how the vote will be split on that one?
I mean, I think that, Gorsuch is a big question because he's the author of the Bostock opinion, finding that the federal statute prohibiting sex discrimination in employment also prohibits discrimination on the basis of sexual orientation or gender identity. It feels like he is at least gettable. He asked, as I recall, 0 questions in this oral argument, which made it very difficult to read him. But I think he's gettable.
Is there any other significant decision that has the liberals plus Gorsuch against the other 5?
Yeah, I mean, there have been 3 federal Indian law cases that it was a majority in one, and then when Ginsburg was replaced by Barrett, they became a 4-member dissent in essentially a variation on the same case in federal Indian law. Another federal Indian law case where, again, they were in dissent about a year later. And those are the big ones. I believe I think there's another immigration case or 2. So it's not unheard of. But I think so. He's the big one, and I think that probably the others are going to vote for Tennessee and allow this ban to remain in place.
I meant to ask this before because I always make a small speech when we talk about the dangers of a certain kind of criticism of judges, because people might listen and say, "Well, that's all you guys have been doing," about Alito and Thomas and others. And so, I guess my question to you is: obviously, we all agree that judges are not above criticism. You do it, I do it. It's part of our First Amendment right, and that's how we understand what's going on, and people have their opinions, and that's totally fine. How would you articulate the limits of rhetorically of how one should talk about judges and their decisions, and where is the line, and how do you justify it?
Yeah, I mean, I think that it's definitely not where John Roberts would draw, because John Roberts, right, has in his year-end report basically suggested that individuals who criticize the court forcefully are complicit with actual threats to the safety of federal judges. And I just think that's
too much.
Just like a wild overclaim that is maybe designed, but certainly could have the effect of chilling legitimate criticism of the court. So, I mean, I agree. I think it's important to condemn frequently and forcefully violence, threats of violence against judges. That is abhorrent. And also, it is entirely distinct from engaging in good faith dialogue and critique of justices who I think are making a hash of certain constitutional principles. I think they're wrong about the Constitution, and I think it's critical that we be permitted to say that. And it's essentially collapsing totally different things for Roberts and others to suggest that there's something problematic or dangerous in criticizing the court. We criticize the president. We can criticize members of Congress. We can criticize federal judges. And it's important when they get things wrong for us to be able to do that.
Thinking a lot about what's missing from our dialogue. And it's not necessarily, an absence of bias, although that's a problem. A lack of listening to other people. All those are sort of subspecies of something that I might describe as the waning of thoughtfulness and the rise of thoughtlessness. And so when you apply that question to the court, could you describe in your words what a thoughtful Supreme Court opinion is? Whether you agree, and feel free to say that there are opinions and dissents that you disagree with, but you still find to be thoughtful, and whether or not it is true that the level of thoughtfulness in the Supreme Court has decreased.
It's a good question. I don't think I've really thought about it in those terms, although I will shout out another piece by another NYU colleague of yours. Jeremy Waldron has this really good book from last year called Thoughtfulness and the Rule of Law. That's really wonderful. But it's not really about Supreme Court opinions. So, individual opinions versus kind of bodies of work. I because I read so many, I guess sitting down and thinking about what is a thoughtful opinion and what is not. But I mean, I think a few things. One is kind of fair recitation of the facts of the case and description of the actual nature of the dispute. I mean, I do think there has been an uptick in what really feel to me like pretty gross mischaracterizations of the facts and the kind of disputes underlying the legal questions that the court is addressing. And that certainly is not a hallmark of thoughtfulness, essentially shading the facts in order to support your preferred disposition of the case. There's the kind of, so I'm a little telling you what I think is not thoughtful, but hopefully that works. Back to the kind of immunity decision, in some ways it is one of the least, that's a John Roberts opinion, and it's it's a 6-3 opinion, even though Barrett disagrees with some parts of the majority opinion. But giving the president this just radical absolute immunity for lots of the things that he does, and qualified or presumptive immunity that might actually be absolute immunity from all the other official stuff that he does, that is just, I think, completely impossible to defend under any of the kind of recognized modes of constitutional interpretation. And if you think that when you decide what something in the Constitution means, you're supposed to look at text and history and structure and what previous courts have thought about a question and what previous presidents and Congresses and the kind of broader legal culture have thought about a question, all of those are recognized modes of constitutional interpretation, and they are completely ignored in that majority opinion. There's a little lip service made to a couple of them, but for the most part, the thing that John Roberts says matters is like what it would do to the presidency and like what it would mean for the president to face the prospect of some potential future criminal liability. And it is just this kind of pure outcome-driven pragmatism that I think is not thoughtful, and it is not thoughtful both in viewed in isolation, but also in the context of a broader body of work that has often been really contemptuous of the propriety of judges even like thinking about and considering the consequences of different rulings. But I'm going to sort of sit with a question a bit, because I think you're right to sort of ask. It's not like, are you doing, is the kind of, because I'm a little bit shifting to constitutional methods and sources, and maybe the thoughtfulness question is different, but that's my best take on it right now.
I mean, I haven't defined it, but I've been thinking about it. Because you can read an opinion that you disagree with and not be offended by it.
I did that with Justice Scalia's opinions all the time. I still do. I think they're mostly really thoughtful, even if most of them I disagree with.
Who's the most thoughtful Supreme Court justice? I don't know. I was going to limit it to the current court, but let's say like in recent times.
Well, I'm duty-bound to say Justice Stevens because that's what I clicked for.
Wow.
And he really was an incredibly thoughtful jurist.
Putting him aside for a moment.
Yeah. David Souter, I might say. Souter was an incredibly thoughtful jurist thinker.
Do you think that's because he spent a lot of time in nature?
Yes, I might. I mean, I don't know for sure, but it might. No, my answer is not facetious either. I actually think that there was a purity to the way he approached questions, and I don't know whether sort of his solitary, kind of life, both before and after the court might have something to do with that. I don't know.
Somebody recently, I saw this quote from someone who said, you want a good idea, you want to come up with something good as an idea, take a walk.
Mm-hmm. Without headphones in.
So I've been taking a lot of walks, and I haven't come up with anything. And what about, can I ask you this one final question?
Yeah,
what
sure.
about least thoughtful?
On the current court?
Current or recent?
Yeah. I mean, I think whatever the denominator is, it's Alito. I think it's Alito. I think that
he's less thoughtful. How do you distinguish his level of thoughtfulness from Thomas?
I think Thomas is often pretty thoughtful, actually. Yeah, I do. I think, again, I would put him, I not all the time, but I think that like Scalia, he kind of believes things. And I also don't think he mischaracterizes facts and or at least plays fast and loose with them in the way that I sometimes see Alito do. I think that the whatever shortcomings I see in Justice Thomas's writings, I don't think they're thoughtless, but I think Alito's are.
I think Alito is definitely the most cranky pants.
Okay, so that you're right, but the answer could be the same to the two, but yeah. They're not necessarily synonymous.
We can do a study.
Yes.
Does level of cranky pants, is that coextensive with level of thoughtlessness? Anyway, these are questions for another time. I've kept you very long already. Professor Kate Shaw, thanks so much.
Thanks, Preet. I really enjoyed it.
Hey, folks, never miss an episode of Stay Tuned. Hit that subscribe button now. If you'd like to support our work, consider becoming a member of Cafe Insider. You'll get exclusive access to a weekly podcast I co-host with Joyce Vance and other great subscriber benefits. Just head to cafe.com/insider to learn more and to join. That's cafe.com/insider.